Before we begin, I apologize for some of the background noise. I'm in a large room with not very good acoustics. So with that said, good afternoon. Today is Thursday, September 19th, 2024. This is an adjudicatory hearing before the Massachusetts Gaming Commission relative to the alleged noncompliance of Crown MA Gaming LLC doing business as DraftKings. With Massachusetts General Law, Chapter 23N, Section 13D, 205 CMR 247.077, and 205 CMR 248.103, I will refer to Crown MA Gaming LLC as DraftKings. My name is Jordan Maynard, and I'm the interim chair of the commission. I'm joined today by my colleagues, Commissioners Eileen O'Brien, Brad Hill, and Akeisha Skinner. The entire commission will preside over the hearing and decision of this matter. This hearing will be conducted in accordance with 205 CMR 101.01, Massachusetts General Law, Chapter 30A, Sections 10 and 11, and 801 CMR 1.02, the Informal Fair Hearing Rules. This hearing is being conducted via remote collaboration technology. I would like to explain the process that will govern this proceeding. First, a notice of hearing was provided to DraftKings in advance of today's hearing. It identified the alleged noncompliance incidents that will be the focus of the Commission's attention at this hearing and the relevant statutes and regulations. Several pre-hearing conferences were also conducted. Pursuant to Massachusetts General Law, Chapter 23N, Sections 4 and 16, and 205 CMR 232, the Commission may hold this adjudicatory hearing and at the conclusion of the hearing may decide to issue a civil administrative penalty, impose conditions on DraftKings license, suspend DraftKings license, revoke DraftKings license, reprimand DraftKings, and or assess a fine on DraftKings. Again, that's according to our law. I see that a number of lawyers are present here today on behalf of the parties. I will ask that each of you please identify yourself and advise the Commission to whom you represent. Let's begin with IEB.
Good afternoon, Chair and Commissioners. Zach Mercer on behalf of IEB.
Good afternoon, Commissioners. Pete Harrington, Senior Counsel for DraftKings.
Thank you, Pete. Anyone else to introduce, Zach or Pete?
Also present, we have IEB Director Caitlin Monahan and Interim CEC Kathleen Kramer. I'll be conducting the evidence in the matter, but they are also present.
Thank you.
With me is Jake List, Senior Director of Regulatory and Risk, and the requested witnesses, Bill Curtis from DraftKings Licensing Department, Jeremy McCulley from our technical product side, and Joe McCann, our incident manager.
Thank you, Pete. At the conclusion of my opening comments, this proceeding will commence with opening statements. Both the IEB and the licensee will be offered an opportunity to make a statement outlining the case they intend to present. Either may decline to make a statement, or in the case of the licensee, defer until the beginning of its case. After opening statements, we will move to the presentation of the evidence in this matter. First, the IEB will be called upon to present its findings as described in the investigative reports and any other applicable evidence. Any commissioner may ask any question of any witness being presented at any point during or following the presentation. At the conclusion of the testimony of each witness, the licensee, through its counsel, will be afforded an opportunity to cross-examine the witness as to any matter addressed in the investigative reports or to which he or she testified. At the conclusion of IEB's presentation, the licensee will be given an opportunity to present its case. The licensee may call any witnesses and present any other evidence it desires. At the conclusion of the direct testimony of each witness, counsel for the IEB will be provided an opportunity to conduct a cross-examination of the witness. As before, any commissioner may ask any question of any witness at any time during the examination or at the conclusion of the examinations. We will allow very limited redirect and recross of a witness. Either party may raise an objection it desires at any time. However, the basis for all objections must be clearly stated. I will note that the commission will make a decision totally on those objections, so the complete commission. Finally, at the conclusion of all the evidence, the IEB and licensee will each be provided an opportunity to make a closing statement, summing up the respective presentations. I'm going to go through the exhibit list, so everyone bear with me. Before we begin, I understand that there are pre-marked exhibits that have been prepared in advance of this hearing. Those exhibits are identified on the exhibit list that have been circulated. They are as follows. Number 1, notice of hearing, August 19th, 2024. Number 2, IEB interview of Jacob List, April 25th, 2024. IEB number 3, IEB interview of Bill Curtis, May 2nd, 2024. Number 4, IEB interview of Jeremy McCauley, May 22nd, 2024. Number 5, IEB interview of Paul Lieberman, June 24th, 2024. Number 6, the Wells email, January 26th, 2023. Number 7, the Wells email related correspondence, January 26, 2023 through May 30th, 2023. Number 8, DraftKings instant message screenshot. Number 9, DraftKings response to Wells email, January 26, 2023. Number 10, DraftKings incident report, June 21st, 2023. Number 11, DraftKings incident report, August 1st, 2023. Number 12, DraftKings correspondence with MGC SWD, July 14, 2023 through August 4th, 2023. Number 13, DraftKings credit card certification correspondence, July 26, 2023. Number 14, DraftKings credit card fund certification, July 26, 2023. Number 15, DraftKings credit card block screenshot, July 26, 2023. Number 16, IEB noncompliance review report, October 20th, 2023. Number 17, IEB supplemental report and attachments, January 22nd, 2024. Number 18, DraftKings incident report, February 13th, 2024. Number 19, DraftKings testing and monitoring of responsible gaming controls memo, submitted February 13th, 2024. Number 20, DraftKings response to IEB supplemental questions, March 29th, 2024. Number 21, DraftKings list of Massachusetts pools entries using credit card funds. Number 22, DraftKings list of quote high risk end quote areas via email May 7th, 2024. Number 23, DraftKings correspondence with MGC SWD June 9th, 2023 through June 28th, 2023. Number 24, IEB supplemental investigation report, July 26, 2024. And finally, number 25, IEB update to supplemental report dated July 26, 2024. Are there any objections to exhibits 1 through 25 being marked and entered into evidence?
None from the IEB.
No objections.
Thank you. Those exhibits shall be admitted into evidence. In order to maintain a clear record, I ask that the documents are referred to by exhibit number as we're discussing them, please. At this point, I will ask if DraftKings would like to stipulate to exhibits 16, 17, 24, and 25, which are the IEB reports dated October 20th, 2023, January 22nd, 2024, and the 2 reports dated July 26, 2024. Mr. Harrington.
Yeah, DraftKings will stipulate to those exhibits.
Thank you. If any party would like to have any additional documents entered into evidence during the course of this hearing, I would ask that they be properly introduced and marked. The Commission anticipates that its inquiry at this proceeding will be limited to the matters addressed in the investigative reports and contained in the notice of hearing. In the event that a line of questioning conducted by the Commission moves into an area that has not been included in the report or notice, but that is material to the final determination of this matter, the licensee may request a recess in the proceeding in order to review that issue. A proceeding of this nature necessarily requires the consideration of a wide variety of information that takes several forms. In this case, some of the information and documentation may include commercially sensitive information. The public discussion of such information may place an entity at a competitive disadvantage if such information were to be publicly discussed. For the Commission to be able to execute its legal obligations effectively and diligently prior to making a final finding, it must be at liberty to fully inquire relative to any of these sensitive matters without compromising the individuals or entities involved. To do otherwise would be at a minimum unfair and potentially unlawful. Accordingly, my colleagues and I may elect to exercise the discretion afforded in accordance with 205 CMR 101.01, paragraph 7, to close this proceeding to the public to fully address certain matters. Under this same regulatory section, DraftKings may request that portions of this hearing be closed to the public as well, and any such request will be considered in turn. I will add that no final decision will be made at the conclusion of the public portion of this hearing. Instead, at the conclusion of the proceeding, the Commission will privately deliberate and ultimately issue a written decision. If at any point during the Commission's deliberations, it determines that additional testimonial or documentary evidence is desirable, it reserves the right to ask for such evidence prior to a final decision being made. This is my favorite part because I have to click through a lot of boxes to make sure, but we will now swear all the witnesses in. Anyone who will be testifying at this proceeding, please raise your right hand. Just a second. Okay, keep your hands up, everyone. Do you solemnly swear that the testimony you will provide before the Commission at this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. It's Michael Banks answering yes, Mr. Chairman.
Thank you, Mr. Banks. Everyone else, yes? I'm clicking through to confirm for the record.
Yes.
Yes.
All right, I will note that any person that joins will also have to be sworn in, okay? Because I do know that you said that someone will be joining late.
I think you should just say that it's noted for the record that all the people identified as potential witnesses have answered in the affirmative to the oath.
Absolutely, I will say that, Commissioner O'Brien. I just also wanted to make sure that we didn't miss the potential witness that comes in at 2:30. So, for the record, all have responded in the affirmative, and I clicked through every box to make sure. Before we begin, does DraftKings have any preliminary issues or objections?
We do. As you stated, Chair Maynard, given the subject of today's hearing is going to involve including the information in the various IEB reports is necessarily going to involve a discussion of DraftKings confidential internal policies and procedures, including how we manage and institute regulatory compliance and guidance, as well as sensitive technical information related to how our financial platform is constructed and operates, which we believe, if discussed publicly, could cause us competitive harm. We respectfully request that the hearing be conducted in closed session pursuant to 205 CMR 101.017.
Thank you, Mr. Harrington. I do have a clarification right now. Do you mean the entire proceeding, or just pieces of the proceeding that would necessarily require?
So, from DraftKings' perspective, the entirety of this procedure, it's difficult after reviewing the IEB's various reports to see how the connected events are not going to, in total, involve a evaluation of how we institute our internal policies and procedures, in particular with respect to actioning the implementation of regulatory requirements, which we consider to be a sensitive and confidential business practice. And then as moving through the timeline of this event, as the subject of this involves how our financial platform operates in order to institute the restrictions required by the Commonwealth under the regulations, how we initially actioned that, and any deficiencies in that regard is going to involve the inner workings. So to the extent that the commission believes that there are portions of this that are not related to that, we would agree that those could be discussed in the public session, but it's difficult from review of the IEB's report to see how they're not all interconnected. But to the extent that the commission believes there are things that do not fall under those, we don't need to discuss those in a closed session. But given that the breadth of this is going to touch on that in any way, that would be DraftKings' position that the entirety should be. If there are portions after the fact that the commission believes could have been stated in the public, we could restate those on the record if that's preferable.
All right, thank you, Mr. Harrington. Commissioners, I think I would take this moment to read the language aloud so we don't make a decision without thinking about it. 205 CMR 101.017 says any adjudicatory hearing conducted under 205 CMR 101.01 may be closed to the public at the request of either party or on the commission's own initiative in order to protect the privacy interests of either party or other individual, to protect proprietary or sensitive technical information, including but not limited to software, algorithms, and trade secrets, or for other good cause shown. Such a determination rests in the sole discretion of the commission. So with that said, commissioners, we've heard Councilor Harrington. How do we feel about making this entire proceeding private session? Commissioner O'Brien, I see your mic is on.
Yeah, there's a lot of the communications between staff and our staff, between the two, the company and us, they're public records. And so by that fact alone, I think the discussion of those lines of communications, they're public, and we really don't have a justification for going private about it. I have certain questions about the application, awareness of the statute, the op certificate compliance check by GL, all of that is public. So I absolutely agree if we get into the line of questioning that goes into their platform, internal compliance strategy decisions, that is a private session topic. But I think there's a fair amount that can be discussed in public before we go there.
Thank you, Commissioner O'Brien. Commissioner Skinner, I see your mic is off.
I agree completely, and I won't belabor the point, and just in the interest of time during this proceeding, repeating everything that Commissioner O'Brien said, which I, again, agree with 100%. I also have some of the same questions or similar questions to what Commissioner O'Brien just described that I also believe can be discussed in public, asked and answered in public, with the understanding as well that if there are sensitive topics that we should not be discussing in public due to their proprietary or competitively sensitive nature, then we should be going into that private session. But at this point, at the top of the proceeding, I don't think that the time is now.
Thank you, Commissioner Hill.
Agreed.
All right, so there's consensus on that. Councilor Harrington, as we move forward, you will have to raise that issue as you believe it comes up. Okay?
Understood.
All right. With that, I ask the IEB to make its opening statement if it desires to do so.
Thank you, Interim Chair Maynard. Good afternoon once again, Chair and Commissioners. The matter before you today alleges that temporary Category 3 sports wagering operator, Crown MA Gaming LLC, doing business as DraftKings, was in violation of Mass General Laws, Chapter 23N, Section 13, 205 CMR 247.077, and 205 CMR 248.103 from March 10th, 2023 until February 16th, 2024, for allowing the use of credit card funds deposited in other jurisdictions and wagers in Massachusetts. By way of background, on May 31st, 2023, DraftKings self-reported that it had been allowing the use of credit card funds deposited in other jurisdictions and wagers since its launch on March 10th, 2023. Following this disclosure, DraftKings submitted a report to the Commission detailing the incident, indicating that the matter had been resolved by way of a software update implemented on May 31st, 2023. However, on July 14th, 2023, DraftKings once again contacted former sports wagering director Band with an update on the matter. In that communication, DraftKings indicated that the attempted fix of May 31st was ineffective and that it had continued to accept wagers funded by credit cards up until that date. DraftKings went on to state that an effective remedy had now been implemented. On July 26, 2023, following a request from the Commission Sports Wagering Division, DraftKings submitted a certification signed by Crown MA Gaming LLC CEO Paul Lieberman, stating that it had blocked the use of credit card funds in wagering in Massachusetts. Following initial review of the matter by the IEB, it was originally scheduled for an adjudicatory hearing before the Commission on February 14th, 2024. On February 13th, 2024, the day prior to that hearing, DraftKings disclosed to the IEB that it had accepted 2 additional wagers funded by credit card funds in that time period, following its purported effective resolution, these occurring on its pools product. Upon this new information being presented to the Commission at that February 14th, 2024 hearing, the matter was continued and the IEB was assigned to conduct further investigation into the incident. The IEB began an investigation into the cause of the incident, the findings of which are the substance of the case in chief today. You'll hear from IEB civilian investigator Michael Banks, who will explain the scope and methodology of the IEB's investigation. You'll also hear from Mr. Banks on the findings made following interviews of 4 DraftKings employees involved in the matter and a review of relevant documents obtained pursuant to this investigation. In addition to Mr. Banks' testimony, the IEB has submitted 25 exhibits. These include the aforementioned interview, incident reports submitted by DraftKings, correspondence between the operator and various parties within the MGC, and the IEB's reports. All told, this evidence will show that through the entirety of the incident, DraftKings accepted 1,160 wagers funded by credit cards, placed by 218 users with a total handle of $83,663.92. Standard of review in this matter is dependent on the action sought by the Commission. If the Commission intends to impose a civil administrative penalty following hearing, the IEB must prove the occurrence of each act or omission by a fair preponderance of the evidence. If the Commission elects to condition, suspend, or revoke DraftKings' license, that decision must be supported by substantial evidence, which is defined as such evidence as a reasonable mind may accept as adequate to support a conclusion. Following the presentation of its case, the IEB will establish its evidence to satisfy both standards. At the conclusion of that evidence, I'll return before the Commission to ask that you find adequate evidence to determine DraftKings was out of compliance with Massachusetts statute and regulations from March 10th, 2023 to February 16th, 2024.
Thank you, Councilor Mercer. I will now ask the licensee to make its opening statement if it desires.
Sure. At this time, DraftKings would just like to reiterate with respect to this incident that this is a matter that we have taken very seriously throughout, and we hope that that seriousness comes across to the Commission through the information we've provided to the IED through the process of its investigation, through the remediation efforts that we've undertaken in response, and any responses that we provide today.
Thank you, Councilor Harrington. I'm going to ask the IEB to move forward with calling any witnesses it intends to call. I will remind everyone that let's try to keep a clean record as we move forward. So with that, Councilor Mercer, would you like to examine any witnesses?
Certainly. Thank you, Chair. The IEB calls Michael Banks.
Mr. Banks.
I am here, Mr. Chairman.
Good afternoon, sir.
Good afternoon.
Could you please state your name for the record?
My name is Michael Banks.
And Mr. Banks, what do you do for work?
I'm an attorney. I'm also a IEB civilian contract investigator for purposes of 23N suitability process.
And how long have you been an IEB civilian investigator?
Since October of 23.
And could you,
2022, sorry.
could you describe some of your past experience for the commissioners, please?
Yes, prior to that position, I was a sworn member of the Department of State Police. I was assigned to the Gaming Enforcement Unit from 2016 to June of 2022 when I left the State Police. Prior to that, I was in the Middlesex County District Attorney's Office as a trooper and homicide investigator since 2004. Prior to that, I was on patrol with the Massachusetts State Police. And prior to that, I was a prosecutor in the Middlesex District Attorney's Office.
Thank you, sir. And in the time period following February 14th, 2024, in your capacity as an IEB civilian investigator, were you asked to participate in any investigations regarding sports wagering operator noncompliance?
Yes, I was. I was asked to conduct a review of a universal wallet violations of DraftKings.
And sir, regarding the scope of that review, could you explain the initial steps that were taken in the investigatory process to effect that review?
Yes, we came up with a strategy to inquire with DraftKings via some written questions relative to the submissions that they had sent, incident reports relative to these potential violations. The purpose of those questions was to maybe fill in the blanks of some questions that we had and act as a platform for further in-person interviews to determine what had happened and why it happened.
And sir, following that initial review of documents, did the investigation endeavor to schedule some interviews with individuals employed by DraftKings?
Yes, we interviewed 4 individuals.
And sir, just to explain a little bit of the methodology behind this to the commission, was the first interview conducted with a Jacob List, Senior Director of Regulatory Operations for DraftKings on April 25th, 2024.
Yes.
And could you explain what the investigation's intent was with speaking with Mr. List first?
We thought that that was a good place to start due to his role in regulatory operations. We were using it to get an overview of the incident from his perspective and identify other individuals who may be able to help us and understand what happened.
And sir, following that interview, did the IEB or did the investigation seek information from Bill Curtis, Director of Licensing for DraftKings on May 2nd, 2024?
Yes.
And could you explain what the purpose was in seeking Mr. Curtis for an interview?
Part of the submissions from DraftKings and their incident reports referred to an email that had been sent by then Executive Director Karen Wells. Mr. Curtis is the Director of Licensing, and we thought that that would be a good start as to understanding the communication that they received, where it went, and how it was returned back to the Gaming Commission and the IEB.
And sir, you made reference in your description of the interview with Mr. List and the intent there. Following the interview with Mr. List, was the IEB provided with the identity of an individual within DraftKings that was identified as someone who could help the investigatory team better understand the product issues or the platform issues involved in this incident?
Yes, he indicated Jeremy McCauley, who was the Director of Product, would be a person who would be able to provide us with a lot of the information, or most of the information that we were seeking as to the whys and hows.
And was that interview conducted on May 22nd, 2024?
Yes.
All right. And sir, now due to the nature of the interview or the type of conversation that was sought from Mr. McCauley, could you explain if the investigatory team sought any assistance from the MGC's gaming system, a gaming systems analyst within the information technology department?
Yes, we brought in Nathan Saylor from the MGC to assist with the technology portions of these interviews, or the subject matter of technology.
And when you say assist with that subject matter of technology, could you explain kind of what the intent was in bringing Mr. Saylor in to assist the team?
Yes, you and I had both participated in these interviews, and we understood that there would be a lot of discussion relative to software technology, and neither one of us having experience to be able to perhaps understand. Mr. Saylor would be able to assist us in laying that out in layperson's terms if necessary.
Thank you, sir. And moving on to the fourth interview conducted by the team, did that occur with Paul Lieberman, CEO of Crown MA Gaming LLC, who also serves as president of Global Product and Technology for DraftKings on June 24th, 2024?
Yes.
And what was the reasoning behind seeking an interview with Mr. Lieberman?
He's the CEO of our applicant. He is in his role. He's also president of Global Product and Technology. He signed the certification after the July 13th fix. So we wanted to get his input on what his involvement was in terms of the fixes that were implemented.
Thank you, sir. And in regard to the documents that you were able to review, in addition to these interviews, was a report submitted or report generated basically explaining the findings of that investigation, which has been marked and submitted to the commission as Exhibit 24?
Yes.
Now, I'd like to draw your attention to this specific investigation or the chronology of the investigation of the incident that you were tasked with looking into. During that review, were you able to review correspondence between former executive director of the MGC, Karen Wells, and DraftKings?
Yes.
And with permission of the commission, I'd like to screen share an exhibit if that's all right. I'm seeing nods in the affirmative.
That's fine with me, Counselor.
I will do that. I'm just checking. Mr. Banks, if you could see, Mr. Banks and the panel, if you could see the exhibit that's currently projected. It's an email printout, basically, on the screen.
Yes.
All right. And Mr. Banks, do you recognize this, which has been marked as Exhibit 6?
I do.
All right. And what is that?
That is a copy of an email sent by Executive Director Karen Wells on Thursday, January 26th, 2023 at 10:34 in the morning to Rebecca Hoffman of DraftKings.
And sir, without reading the email verbatim, does that email ask a series of questions regarding the quote unquote universal wallet capabilities of DraftKings prior to launch in Massachusetts?
Yes.
And sir, in the course of this investigation, did you come to learn if DraftKings responded to that email?
Yes, I did.
And I would like to direct you, sir, to exhibit number 9. Is that the email that was sent in response?
It is.
Okay. And sir, is that essentially the same questions that were asked by Director Wells? And then there are I believe you can see a navy blue font following those questions on this letter on DraftKings letterhead. Those would be responses that were provided to those questions.
Yes.
Now, sir, you stated that in your overview of the nature of this investigation, and let me just for the moment conclude screen sharing. Sir, did you have occasion to discuss the nature of the receipt of this correspondence from DraftKings with Mr. Curtis?
Yes.
Okay. And you stated before that Mr. Curtis, his title within DraftKings is Director of Licensing, correct?
That's right.
All right. And the individual that he had sent that email, that email had been sent to, a Rebecca Hoffman, she's an individual that works under Mr. Curtis within the DraftKings licensing department.
Yes.
Okay. And sir, did the interview of Mr. Curtis touch upon the process in which Ms. Hoffman handled that letter?
Yes, it did.
Could you explain a little bit of what we learned or what you learned from the interview with Mr. Curtis regarding that email?
Yes. So Mr. Curtis explained to us that it had been because Mr. Curtis was once an employee of the Mass Gaming Commission, that he believed that direct communication with the executive director or the MGC may have an appearance of favoritism. So in order to prevent that, he had communications between our agency and DraftKings, as far as licensing goes, to go through Ms. Hoffman. So Ms. Hoffman had received this email from then Executive Director Wells. Mr. Curtis explained to us during the interview that Ms. Hoffman consulted with him as to what to do with that email. And they both agreed, Mr. Curtis and Ms. Hoffman, that that should be sent to a subject matter expert, which is a term that I've come to learn is used quite a bit in DraftKings for their different their employees and their areas of responsibility. It was initially, Mr. Curtis recommended that it go to Dixon J. However, once received by Dixon J, as I understood it from Mr. Curtis, and subsequent information that we received, he was not the appropriate subject matter expert.
Let me just stop you there for a second to unpack a moment, sir. So Dixon J, did you learn in the investigation that his title is Director of Payment Operations within DraftKings?
Yes.
And when you say you came to learn that Mr. J was not, in fact, the correct subject matter expert, as you say, to answer the questions that were sought by Director Wells, he in turn asked another individual within DraftKings. Did you learn who that was?
Yes, I did. I believe Ms. Tate, Grace Tate.
That Grace Tate, and her title being Senior Product Manager.
Yes.
And sir, in the course of this investigation, in your review of the documents, was the investigatory team provided with a screenshot of an internal instant message conversation between Mr. J and Ms. Tate?
Yes.
Turning once again, to exhibit what has been marked as exhibit number 8, if everybody can see that, appears to be, I'm sorry, it's slightly cut off on the PDF, appears on your screen, but I believe you can ascertain from the last names that are present on exhibit 8 who is speaking. Is that the conversation that you're able to review, Mr. Banks?
Yes.
And could you explain basically what we see here?
Yes, so this is instant messaging, which is, we came to learn from Mr. Curtis, is a way in which communication is done within the DraftKings organization. And this instant messaging is from Dixon J to Grace Tate, reiterating the questions from Director Wells's email. And the responses were given by Ms. Tate and sent back to Mr. J, so that ultimately back to Ms. Hoffman, who then included it on DraftKings letterhead and returned it back to then Executive Director Wells.
All right, and sir, just to further elaborate, we previously viewed exhibit 9, which was the letter or the email in response to Director Wells' email. Was the answers provided on the letter signed by Ms. Hoffman, are those essentially the same exact answers that we just viewed on that that instant message chain?
Yes.
And sir, upon review of the responses that were submitted by DraftKings and ultimately in the context of the larger investigation, did it appear that the capabilities that were explained there were accurate as to the capabilities of DraftKings system?
Yes.
Now, sir, isn't it true that DraftKings launched in Massachusetts on March 10th, 2023?
Yes, they did.
Okay. And sir, as part of this investigation, did you also become aware that DraftKings had notified the Sports Wagering Department of the Mass Gaming Commission on May 31st, 2023, that it had not been compliant with Massachusetts statute and regulations prohibiting the use of credit card funds and wagers?
Yes.
And DraftKings submitted an incident report in regard to that matter on June 21st, 2023, which was marked as Exhibit 10. Is that correct?
Yes.
And without examining the entirety of that report, is it fair to say that one of the credited reasons for the failure to implement that process was a misinterpretation of Ms. Wells' email?
That was cited as a reason.
And sir, starting from this broad initial standpoint of this incident, did the investigation discuss the machinations surrounding that incident with Mr. List in the interview that you previously spoke of?
I'm sorry, could you just repeat that question?
Certainly. Did the investigators speak with Mr. Jacob List from DraftKings in regard to the circumstances that led to that initial issue?
Yes, we did.
All right. And could you describe, if Mr. List described the process that DraftKings undergoes to launch its platform in new jurisdictions such as Massachusetts?
Yes, he did.
Could you describe that for us?
In summary, during our interview, when prior to launching or entering into a jurisdiction, they receive either the existing regulations or the proposed regulations or emergency regulations, and they're literally placed into a spreadsheet and itemized and prioritized. They then seek out input and feedback from the relevant teams relative to any particular regulation of that jurisdiction, determine whether or not they already have existing technology or systems in place to be able to meet compliance with a particular regulation. And again, they also queue those based on high priority. Excuse me, my light went out. My apologies.
No worries, sir.
In any event, they will, as I said, they will queue those as some being high priority that should have maybe different layers of attention. He didn't use that word, but that's what I took away from it, whether it be additional testing or what have you. Once those are received, being in the feedback is received, they were able to, in consultation with legal, reg, technology engineers, be able to create implementations to meet regulations in any particular jurisdiction.
Now, sir, did this interview touch upon obviously the specific central investigatory point here of the implementation of a block on out-of-state credit card wagers, out-of-state credit card funds being used in wagers on the DraftKings platform?
Yes, we discussed that.
All right. And did you learn if the handling of that particular regulation fell outside of the structure that you just described?
It did. It did.
And could you elaborate on that? If
Yes. So they did have, when they do test and they do conduct a process for all regulations, but this particular I'm sorry, I'm searching for a word. In any event, this payment processing with credit cards was not. There was geolocation, which was in place and had been tested, which my understanding is at the time that they interpreted the regulations, it was sufficient to launch in Massachusetts.
And sir, in the course of this investigation, did you learn that on July 14th, 2023, DraftKings contacted the sports wagering division in regard to the same universal wallet issue?
Yes.
And in that communication, did DraftKings indicate that the May 31st attempt at blocking funds derived from credit card deposits was unsuccessful?
Yes.
All right. And did the investigation endeavor to learn more about the processes that led to that failure?
Yes.
And so, sir, originally, so I'm sorry. DraftKings had submitted a report on August 1st, 2023, explaining why its update had failed, and it provided two reasons for that, correct?
Yes.
And that would be
Sorry, can I object at this time? To the extent that Attorney Mercer is going to question Mr. Banks on the specific tech elements, the technology on how this one, I would reiterate my request that those be discussed in closed session.
Thank you, Mr. Harrington. Commissioners, I will not reread the standard. I would be fine with putting this as one commissioner would be fine putting this in the parking lot and letting Mr. Mercer continue with his questions, returning to it in private session since we are talking about the details of the technology, but it's a decision made by all four of us. So, commissioners?
I'm fine going into private session for the details. My question is, can he proceed with the direct examination at a higher level to get broad strokes?
I think that I can do that at this point if it assists the commission in continuing the narrative here, and then once we get into the specific details, which I believe are born from a discussion from this conversation with Mr. McCauley, I think that it'd make sense to double back for that. I think that we can certainly do that. So
I'm fine with that.
Commissioner Skinner, Commissioner Hill?
I'm fine with that as well.
As am I.
All right. So, Mr. Mercer, please go a little broader with your questioning.
Certainly I will. So Mr. Banks, just to essentially explain the nature of how the investigation proceeded at this point, is it true that the investigators sought an explanation as to the reasons for the failure of the update that was implemented by DraftKings on July 13th? I'm sorry, on May 31st, 2023.
Yes.
Okay. And without getting into any specifics, were you able to discuss at length the exact procedures and communications that led to that ultimate failure?
Yes, we did.
And so following that conversation with Mr. McCauley, is it true that time-wise in this investigation, is it true that on July 26th, 2023, DraftKings submitted a certification signed by Crown MA Gaming CEO Paul Lieber?
Yes.
All right, and I'm just going to share my screen here. Sir, I'm showing you what's been marked as Exhibit 14. Do you recognize that document?
Yes, I do.
Okay. And what do you recognize that to be?
That is Mr. Lieber's certification relative to deposits on credit card use, dated July 26, 2023.
Okay, and that was submitted following a request from the Mass Gaming Commission's Sports Wagering Division, correct?
That is correct.
All right, so following that, sir, as we've detailed briefly in the presentation here, ultimately it was learned that there were further wagers made on the DraftKings Pools product, correct? Following the certification.
Yes.
And those wagers were funded by credit cards.
Correct. 2 wagers.
So, sir, with that knowledge at hand and the current exhibit before you, the investigation sought a comment or sought an interview with Mr. Lieberman. Is that correct?
Yes.
Okay. And could you describe if the conversation with Mr. Lieberman by way of that interview discussed what information he had at hand when signing that certification?
Yes, he did. He did.
Okay. Could you explain that for us, please?
Yeah, he signed that. He indicated to us that he wanted to ensure that his team had reviewed the issue, that they understood what the previous incidents were, they addressed it, and they tested it. And with that information, he signed that document.
And sir, did the investigators approach the area of what occurred that the Pools product was still accepting credit card wagers following this?
We learned the reasons why that occurred from DraftKings, and those were wages that occurred prior to the certification, but were discovered after the certification.
And sir, without delving too deeply into the technological processes here, I'll move slowly in case there's a comment from DraftKings in regard to the confidentiality of this. Did you learn what the differences were between the Pools product and the Sportsbook product that led to this oversight?
I learned the difference between the sports wagering products and the Pools products, just from a customer point of view and what those are. And I also learned the technology the technology that serves both.
Okay. And sir, how did, just as an overview, did you learn what the specific distinction is between the Sportsbook platform and the Pools product that make them different for the purposes of DraftKings technology, technically?
From the technology?
As far as kind of what makes them distinct on the platform as far as how they're built.
Yes, so Pools was built in-house, and the other was acquired through technology when SB Tech was, during that acquisition, the technology is used for the other sports wagering products. Pools was an in-house technology that was being utilized, although it's all on the same platform from a user standpoint.
And sir, when speaking with Mr. Lieberman, were the investigators able to learn how those wagers on August 18th, 2023 and January 13th, 2024 were identified on DraftKings end?
Yes, we were.
Could you explain that for the commissioners, please?
Yes, so Mr. Lieberman explained how after he began oversight over the remedial measures that were incurred due to the prior 2 fixes. Included in that was, detection. He described essentially a layered approach of dealing with this issue was, preventing it in the first place. Let me just refer to my notes for a moment. he decided, as he almost described it as a layer cake, prevention, testing, and detection. And he said as a result of that third layer of detection, the remedial measures that were put in place due to the sports wagering incidents uncovered this pools issue, and they were able to address it.
All right, thank you, sir. Now, just so we have the basically, in the interest of full explanation, did you come to learn what the pools product itself is?
Yes, I inquired because I didn't know.
Yeah, could you describe that just broadly, please?
Yeah, a pools product is a wager in which multiple users will compete against each other. In essence, maybe picking the outcomes of certain sports contests, and basically whoever gets the most right wins is a pools product.
All right. And sir, did you learn that following the discovery of those pools wagers, did DraftKings ultimately close the loophole that allowed for those wagers to be placed?
Yes, they did.
Now, following the interviews in the lead up to this hearing today, were you made aware of a discrepancy in the reporting of the affected wagers that were relevant to this investigation?
Yes.
And so, sir, in what's been marked as Exhibit 12, did you learn that DraftKings had sent an email on August 4th, 2023, detailing that the full accounting of wagers was affected wagers was 242, with a total handle of $83,663.92.
That's correct.
And during the IAB's review of the documents that we have here, including the exhibits that have been submitted to the commission, was a previous email found from DraftKings to the commission indicating that there were 1,042 wagers placed between March 10th, 2023 and July 13th, 2023.
Yes.
And due to this discrepancy, on July 26, 2024, did the IAB seek further clarification?
We did.
And did you become aware if DraftKings did provide additional clarification?
Yes. They provided the total reported wager from March 10th, 2023 to February 16th, 2024 was 1,160 wagers placed by 218 users with the same total handle that they had reported, and indicated that the misreport was due to the amount of wagers, conflating wagers and deposits with the associated wagers, if that makes sense.
Sure. And sir, is it true from the report submitted by DraftKings, it was indicated that the wagers that were accepted using those credit card funds were processed in the normal course of business and no further action was taken?
Correct.
I don't believe I have anything without delving further into the specific area that was cited by Mr. Harrington at this point. So I'd defer to the commission as to next steps.
All right, Counselor, thank you. The way that we would like to conduct this is to allow Mr. Harrington to conduct a cross-examination. And since it's the first one, I'll explain it. We then would allow the commissioners to ask Mr. Banks any questions they have, and then we would allow those limited redirects that we talked about earlier. So with that said, Mr. Harrington, do you have any questions of Mr. Banks?
I don't at this time.
All right, thank you. Commissioners, do we have any clarifications for Mr. Banks? Commissioner O'Brien?
I do have some. So, Mr. Banks, in the course of the investigation, did you inquire of Executive Director Wells whether she'd had any other communications with the licensee on the topic of the universal wallet,
No.
aside from that 126-23 email?
No, I didn't.
And did we ask for a review and production of any internal communications from the licensee relative to complying with the statutory requirement of no credit cards?
Just for clarification, Commissioner O'Brien, during our investigation or
Correct.
prior to our investigation?
During your investigation, there was a production of, I think, what looks like a Slack, chat back and forth on the topic to respond to the email. Did we ask for them to search for any other internal communications that they had going back to the application forward in connection with their compliance with the universal wallet credit card ban requirement?
We did ask initially in our investigation for any written communications, memorandums, emails, or other internal written directions relative to specific issues that were raised in their incident reports. That was in that first supplemental set of documents that we made that request as part of the investigation for this particular incident, but we did not ask, if I'm understanding you correctly, for other written materials prior to these incident reports being filed. In other words, we didn't ask for anything prior to that email that was sent by Director Wells.
Okay. So we could put out a request asking them to go back and historically look whether they had any other internal communications on that statutory requirement. Is that a fair statement?
Yes.
Okay. And then I think the only other question that I have is, well, I'll hold on further questions that I have right now.
Thank
Thank
you,
you, Mr. Banks.
Thank you, Commissioner O'Brien. Commissioner Skinner, I see your mic is off.
Thank you, Mr. Chairman. Mr. Attorney Banks, hello. I'm not sure that it's fair to ask this question to you, but what precipitated the email from former ED Karen Wells? So that Exhibit 6.
I don't have personal knowledge. I can speculate just from the chain, but I don't have personal knowledge of that.
Yeah, I didn't think you would. So, Mr. Chairman, this, by the way, is, I think, this body of four, first adjudicatory hearing whereby IEB is participating as a party. And so I'm not really sure whether I am able to direct questions to the IEB at this juncture or not. Could someone please advise?
So I'm going to turn it over to Councilor Stimpick. I will say that in all the hearings we've conducted, one of the major pieces of feedback I get across the board is sometimes when we start doing our questioning, we get lost a little in the shuffle. So I would like to make sure that we're moving linearly instead of just around. So Mr. Stimpick.
Sure, Commissioner Skinner. So the commissioners, the four of you, are essentially the fact finders in this matter. And under our regs and statute, you have the right to ask the licensee for any information that you feel necessary to make your decision. So rather than making the inquiry through the IEB, because the IEB is a party in this matter, you would be essentially making any inquiry for additional information, whether that be testimonial or documentary, to the licensee, so to DraftKings itself. So if there's other information that you are interested in acquiring, that would be a direct request from you as the commissioners to DraftKings. The IB is a party in this matter, so you would be asking it yourself. Does that make sense?
And so is that a yes? I'm able to ask
yes,
the
you
IEB
can.
a question.
You could ask any question. You can certainly ask the questions that you need to get answers to. And if there's additional information that you feel you need from the licensee, you could ask the licensee to provide that information at a future date if we don't have it now. And that's part of potentially keeping this matter open if it's necessary beyond today. If we don't have it and you haven't had an opportunity to review it, that's within your powers.
So I'd like to know what precipitated Karen Wells' email from January 26, 2023. And if we don't have anyone on who can answer that question, that's something I'd like us to get at a later point.
Would it be possible to take a moment, 5 minutes?
Yeah, let's
Okay
take a recess. Let's take a recess. I will notice.
So that you take the recess, the line of questioning that I had was in the same vein as Commissioner Skinner's in terms of the request for additional information that doesn't necessarily, is not necessarily in the hands of the licensee. And so there might be a list at the conclusion of today's hearing, sort of asking for further follow-up.
I was going to say, Commissioner O'Brien, I don't see Karen Wells here. So, and then
Right,
the perfect person to answer that question is Karen Wells.
Right.
Why she sent that email. So, yeah, let's take a recess. 5 minutes. All right, Connor, if you can take that down, I'm going to see if we're all back in. We'll give our licensee time to get back. All right, I see Councilor Harrington, Councilor Mercer, all the commissioners. So just to reiterate where we are in this process, we're in the middle of questions from commissioners to Mr. Banks, who was called by as a witness by the IEB. We ended with a question from Commissioner Skinner regarding what caused Karen Wells to send an email, which is one of the exhibits. From there, commissioners, do we have any further questions?
I have another question, but are we resolving the outstanding question?
With the permission of the commission, I think that this is something that may be resolved. It may involve an inquiry from Mr. Stempak, just as far as procedurally how we proceed, if I'm allowed some leeway with that.
Commissioner
Yes,
Skinner,
Councilor.
yes, Commissioner Skinner, to my point from earlier, I think if there are outstanding questions of fact that commissioners have, that it bears noting those, and that there can be a follow-up to the licensee with respect to getting answers to those, whether it be documentary or testimonial, so that this, we can keep this hearing open at the conclusion of whatever we get through today. And when we get that additional information, we could reconvene to go over that and answer your questions. So, I will keep a tally of any outstanding questions that we think fit into that category and can follow up with the licensee directly at the conclusion of today's portion of the hearing, if that makes sense.
Okay, so then in that same vein, another question that I have, whether any other operators were sent similar correspondence.
Commissioner
And
Skinner,
I'll be more straightforward, sorry, whether other operators got that same email from Karen Wells, obviously directed to, each operator. And
again, I don't have personal knowledge. I do see from the email that in the first two sentences that she indicates she's sending that out to all of the operators, but I have not seen other emails to other operators.
If I may, so essentially the IEB could present information that would probably likely answer Commissioners O'Brien and Skinner's question. Director Monahan, in her former capacity as Deputy General Counsel, is one of the individuals that CC'd on the exhibit that has been identified as the Wells email. In the event, and this is why I think this needs to be directed toward Mr. Stempak, procedurally, if Ms. Monahan could be sworn in her capacity as former Deputy GC, I believe that she would have an answer that would be satisfactory to the commissioners in regard to resolving that line of questioning. So just for clarification, Attorney Mercer, so my question went beyond Commissioner Skinner's, which is a query on directly questioning Karen Wells as to whether she had any other communications with the operator on this topic. That I don't believe Attorney Monahan is going to be able to answer. She could answer a narrow subset, but I think mine will live a life beyond that, just for the record.
All right. Thank you, Commissioner O'Brien. So let's solve this one issue at a time. Does the commission have any issue with swearing in Director Monahan in her previous capacity to answer this particular question by Commissioner Skinner, understanding that there are larger questions that will not be answered today? I can tell by what's going on here. Are we okay with that, commissioners?
I am.
All right. Now, I will note that this
Does the process allow us to do that, Mr. Chairman?
Yeah.
I'm looking for Justin, and one thing that I'm thinking right away, Justin, is this also means that it wasn't noticed, and the other piece is it would allow the licensee to cross-examine Director Monahan.
I would, given that this given that this piece of questioning is tied into the other piece of questioning that Commissioner O'Brien has, in the event that we would want to utilize Director Monahan as a fact witness and it hadn't been properly noticed for the benefit of DraftKings, I would hold this in abeyance for resolution at a future day when we have resolution of what I imagine would be a number of other factual questions, so that we can provide proper notice to all the parties, etc. I think that's probably the safer course of action. So that would be my recommendation from a legal standpoint. Procedurally, I think we could do it. However, just in being conservative here, I want to give DraftKings proper notice of all of this and not throw a curveball in the midst of this proceedings.
That's fine.
Yeah.
And that sounds like a pragmatic solution too, given that we already have a couple of issues we want to circle back on.
Right.
All right, Commissioner Skinner, do you have any more questions?
I do.
Okay, thank you.
Could we confirm that we're just dealing with credit card deposits from out of state and used in Massachusetts, and not credit card deposits that were made right here in Massachusetts?
The inquiry was relative, and the disclosures were from DraftKings on out-of-state deposits only on accounts. And we have not received, I am not aware of any self-disclosures that there was credit cards deposited, or rather accounts with funds deposited from credit cards within the Commonwealth.
Okay, thank you.
Commissioner Hill, any questions? None from me either. With that said, we would turn it back to Mr. Mercer. Would you like to redirect?
Certainly, I just have some brief clarification of Mr. Banks, if possible. Just directing you, Mr. Banks, back to what has been marked as Exhibit 20 in the Commissioner's packet. Sorry. So, sir, I believe you briefly had discussed the nature of the query that the IEB had sent to DraftKings in the initial stages of this follow-up investigation. I believe you recited from memory some of the questions that we had asked. I just asked if you could take a look at what's designated in that exhibit as 1.1. It looks to be a subsection of the questions that are present. Could you explain further about what the investigators were seeking from DraftKings in relation to the quote-unquote anomalous sequence of events that towing in the quote-unquote Wells email here?
Yes, at the outset of this investigation, when we reviewed the incident reports from DraftKings, they cited, made reference to, quote, anomalous sequence of events relative to a communication breakdown. So what we asked for was for DraftKings to explain what they meant by that specifically, in specifics, and to include any copies of the relevant written communications, including memorandums of emails or other internal written directions. So I guess maybe to further clarify Commissioner O'Brien's question, Commissioner Skinner's questions, is that we did not seek from Executive Director Wells information, but we did request of the licensee to provide everything they had relative to these communications that led to this communication breakdown.
So if I could clarify, that would appear to be related only to the 126-23 email, correct?
Correct. That phrase that they used was in reference to that email.
Okay.
The situation.
So just for clarification on the record, my question is whether there's an ask or could be an ask for any communications internally that goes back to the implementation of the application of this operator up through and including when they discovered the failure to comply.
Understood.
Understood. And I have nothing further beyond that clarification, Mr. Banks.
All right. Thank you, Councilor Mercer. Mr. Harrington.
I have nothing for Mr. Banks.
All right, thank you. So we did have an issue that popped up about the details that we could go into private session on. I will not have to read that back into the record, but we will have to have consensus on that It will be related to Mr. Banks' testimony only is the way that I'm viewing it, commissioners. Are we wanting to enter into private session to ask that line of questioning at this point?
Yes.
I think if Attorney Mercer's at that point, then
That's
yes.
exactly what I was getting ready to say. Councilor Mercer, would you want the opportunity to have those questions?
Yes, please. I believe that this would further inquiry would go into the area that was cited by Mr. Harrington.
All right. All right.
Mr. Chairman, my only question there, if we're going into private session now, is once the operator puts on its case, we'd have to go back into private session to question the witnesses directly regarding similar issues, right? And so I guess what I'm getting at is, does it make sense to hold the private session until you're shaking your head no? What does it make sense to hold the private session until every witness has given testimony so that we can have a more fulsome question and answer session along with that?
The reason I'm shaking my head no is because I think we should keep this record as clean as possible, even though it will create definitely logistical issues. Commissioner Skinner, I think you're 100% correct. Pragmatically, for our team running this meeting right now, I'm sure they would love for us to hold everything till the end. But I want to make this record as clean as possible is the way I'm viewing it. I see Commissioner O'Brien giving a nod.
Yeah, I think as we move forward with other witnesses and maybe the query is narrowed, right, we might be able to cluster some for later. I think given that he's sort of setting the stage for the investigation, it might make sense to just have it presented chronologically. So sliding into private now makes sense. But then I see your point going forward where it may make sense to hold.
So Commissioner Hill, are you okay with us entering into private session? All right.
Yep.
All right. So Councilor Stimpick, I want to make sure I'm doing this correctly. Just for the record, all the commissioners, myself included, have agreed to enter into private session for Councilor Mercer of the IEB to be able to direct some questions to Mr. Banks.
Yep, that's appropriate. You can, by consensus, you can all agree to that we're going to move to private session on with respect to that limited topic area that we previously identified, and we can go in, conduct that line of questioning, and come back out to the public when that's concluded.
All right, perfect. So that's what we will do. I'm going to ask that our team who is putting this together, if they can move us into a private session. Thank you, Connor. Thank you all. We have finished the business. We can take that down, Connor. The business that we have Mr. Banks in private session. We will continue where we left off was Mr. Mercer giving him an opportunity to call the next witness that he has for the IB.
The IB would rest upon the testimony of Mr. Banks, along with the 25 exhibits that have been submitted to the commission. I would note, obviously, with the intent of the commissioners to request additional information, I'd reserve the right to address that on a later date when that's ultimately addressed. But otherwise, the IB rests.
Okay. So with that, we will ask the licensee, Mr. Harrington, would you like to call any witnesses?
We would not. DraftKings is satisfied with the report presented by the IAB and the documentary evidence that has been submitted with respect to this incident.
Okay, thank you, Mr. Harrington. With that, commissioners, do we have any further questions of Mr. Banks first?
Not of Mr. Banks, no.
Okay. So Commissioner O'Brien, in anticipation of what you may be asking, I've been advised by the council on our draft that we should go ahead and let the IEB and DraftKings make closing statements. And then there's an opportunity for us to ask for additional information beyond those statements after.
So if I have questions of the witnesses who were sworn today, now is not the time.
Oh, no, it's right now is exactly the time of any witnesses that were sworn today.
Okay.
Yep. Yep. Oh, no. Well, so that's the witnesses that have testified today first, right? Again, we're trying to keep this record really clean.
Right.
All
No, these are witnesses who were referenced in the summary by Attorney Banks and who raised their hand to take the oath, but have not testified today. I have questions.
Okay, thank you. So what we will do is hold those, please. Let's go ahead and do closing statements. And Councilor Stimpik, can you confirm that that's going to give us the cleanest record?
I think that while we are going through witness testimony, that given that we have other witnesses that have taken the oath, that procedurally we should take all the testimonial evidence now. So if commissioners have questions of additional witnesses that are present, that just so we can get that all in, we could do that before the closings, understanding that these are commissioner questions. But I think procedurally, let's get all the testimonial evidence in now from the folks who are here. Then we can move on to closings, and then if we have outstanding issues, Chair, we could address those outstanding issues when we finish closings.
Perfect. And let me go ahead and procedurally, and that's I won't blame the drafter, Justin. He does a really good job of how we proceed. What we can do is go ahead and if questions are, do commissioners anticipate asking any questions of Mr. Lieberman? If so, he has joined for the record, and I would have to swear him in.
I do have a question for him.
Yeah, I do too.
And just one thing too, Mr. Chair, as we're talking about for the process, it may make sense if we're going to be keeping the evidentiary record open even after the conclusion of today's hearing, that we hold off on closings.
Yep.
Yeah, so we just keep that open. So that makes sense.
Perfect. All right. So,
Sorry, Chair Maynard, before the commissioners get into questions of any witnesses have not been called or testified today, I would just like to request if there are questions that speak to the technical components, which I think won't be directed to either Mr. Lieberman or Mr. McCauley, that those also be gone into private session.
Understood. And I would say, Mr. Harrington, that we would treat it the exact same way we treated the last witness.
Yep.
And that we'll ask as much as we can. You let us know when you think the questioning is getting into private session, and we will make a determination at that time.
Understood.
So thank you for that. Mr. Lieberman, hello.
Hello.
Can you please raise your right hand? do you solemnly swear that the testimony you will provide before the commission at this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Lieberman, and he did, was in the affirmative. So for the record. All right, now commissioners. Questions?
So I actually had a series of questions for Mr. Curtis that I was going to start off with. I don't know if Commissioner Skinner, you wanted to start off with Mr. Lieberman. How do we want to
Nope.
handle it?
I'm going with the flow. I'll follow your lead, Commissioner O'Brien.
So I would ask this, commissioners, I think it'd be helpful for everyone and myself too. Let's go ahead and ask, let's take one witness at a time if
Yes.
possible.
Right.
Before we cross. All right, perfect. Thank you.
Yep.
Commissioner O'Brien.
Sure. So this is for Bill Curtis, who, for the record, we did overlap for a brief period of time when he was here prior to departing over to DraftKings, I believe in 2020. Just so that we're clear on the record on that. So Mr. Curtis, you indicated in your interview that you were, I believe, the director of licensing at DraftKings, correct?
Yes, ma'am.
And that, is it accurate to say that you were listed as the point of contact in the DraftKings Crown Mass LLC application to the Mass Gaming Commission in November of 22?
I don't believe I was. I'd have to go back and look, Commissioner.
Okay, we can circle back in another date. I pulled up the application that was submitted in November 22. You're listed. Mr. Lieberman signs it. You are listed as the point of contact for the agency.
Okay, I am the point of contact, but for this case with Mass Gaming, I declined to be.
I'm gonna get to that. So
okay.
Just for the record, and if it's, you want to come back at some point and show otherwise, it's my understanding from looking at the application submitted by DraftKings in November of 22, you were listed as the point of contact for the MGC. So in the course of the application in November of 22, up through January of 2023, did you have any communications with the MGC in connection with DraftKings application?
The only time I believe I did was to submit the scope of licensing.
And who did you communicate with?
It was just a submission, ma'am. It wasn't, if you mean like verbally speak with someone, no.
And so you, at what point did you designate Rebecca Hoffman to be the point of contact to communicate with the MGC?
I believe once we, I'm just trying to think here exactly because that was a little bit while ago. It could have been when we submitted our application to the commission.
And how was that effectuated? Was there something in writing, an email?
No, ma'am, no.
Okay, and how was that communicated to the commission that the point of contact would not be you and would be Rebecca Hoffman?
Again, I don't remember, ma'am.
Okay. And going back to January, fall of 22 and January of 23, Rebecca Hoffman's title was licensing specialist, correct?
Yes, ma'am.
And how long had you been with DraftKings at that point?
How long had she been with DraftKings?
Correct.
I believe it was September of 2020.
And what was her training and experience prior to you designating her as the point of contact with the Gaming Commission?
Well, she had worked on the employee side for 2 years. She came over to the entity side. She had worked with me on other applications.
And in terms of the org chart in your licensing division, where did she fall in terms of the org structure?
At that time, she fell at the time of the application, she fell directly under me.
Okay. And did you have any other direct reports aside from her?
I did at that time. Yes, ma'am.
At that time, how many?
Yes, ma'am. 2 others.
And they were at the same level she was?
No. Both of them were managers.
So they were above her?
Yes, ma'am.
So she was at the lowest level in the org chart for your group. Is that a fair statement?
She was, but she worked on entity licensing. The other two folks, the other two managers, one of them worked on vendor licensing and the other one worked on employee licensing.
Okay, but she was not a manager, correct?
Yes, ma'am. At that time, no, she was not.
Okay. In January 26, 2023, the email goes to her from Karen Wells. Can you tell me when you became aware of that email and how?
We were in the office that day and she sits right next to me and she just made me aware that she received an email from Karen. And, we discussed it and I just, we came to a determination that who the person should receive that email to answer those questions.
And had she alerted you to any other communications that she had had from Karen Wells prior to that date?
I don't remember.
Did you have any communications with anyone at the MGC regarding the Universal Wallet?
Mr. Band had called me and gave me, a bit of a hard time. He didn't ask me any questions. He just said can't you guys get it straight?
And when was this?
Oh, I'd have to look into my phone records.
So if you could do that and we can circle back, if you could see exactly when Mr. Band reached out to you.
Okay.
Okay. And was those the only communications you had with the MGC on that topic?
Until Zach had, until Attorney Mercer had reached out to me.
So there were no internal communications in the spring and summer when the first fail, we'll call it, was found?
With the MGC?
Internally?
No, I wasn't aware of it.
Okay.
Know what I need to be really. I deal with just licensing. I don't deal with the
Well,
product.
but your person answered the question, correct? In January 26, 2023?
What was the date again? January 20.
The email from January 26,
Yes,
2023.
she did.
Your
She did.
designated person answered the MGC, correct?
Correct.
Okay. I want to direct your attention to Exhibit 20, which is the March 29th, 2023 responses from DraftKings that in some measure talks about that January 26, 2023 email response from your designated contact replacement.
I don't have access to that exhibit.
Can we potentially pull that up?
I could do it if it's helpful.
So my question is, before we do this, is the entirety of this a public document? Anything in here asked by DraftKings to be protected?
I hear nothing, Commissioner.
hearing nothing.
And
Okay.
I do believe this was showed earlier. Was that correct, Councilor Mercer?
It was, yes.
Okay. So directing your attention to what is on the screen, which is question 1 and then 1.1. Do you see those
Yes, ma'am.
on the screen, Mr. Curtis?
Yes, ma'am.
And in particular, the question 1.1 talks about the June 21st report and the communications breakdown. Do you see that?
Yes, ma'am.
And then the answer provided, as stated in the previously submitted incident reports in responses to prior questioning from the MGC related to this matter, the miscommunication occurred as follows. Regulatory guidance prohibiting credit card funds deposited legally in another state from use for wagering in Massachusetts was communicated to DraftKings in the form of an email questionnaire. Normally, such information is communicated as a formal directive. Did I read that accurately?
You're repeating what's written there. Yes, ma'am.
Correct. Can you explain to me the distinction between an email and what this described should have been a formal directive?
Okay. I don't believe I wrote that.
I'm not
But-
asking when you wrote it. I'm asking if you have the capacity to define that for me.
Okay. So, okay. I think what it says there is that it's saying that the questionnaire.
Let me ask you this. Is there a particular form that is viewed by DraftKings in your understanding as a formal directive as opposed to a written email?
Could you repeat that question, please?
Is there something in your experience in working at DraftKings that would
Okay.
distinguish a formal directive from the email that was submitted by E.D. Wells?
I'm trying to think. I mean, can you just one more time, please? That's all I'm asking for.
Have you ever been told of
I haven't
something
done- Correct.
that has been identified as a formal directive at DraftKings?
A formal directive from Karen Wells?
Any regulating authority, it's indicating that it should normally would have been communicated in the form of a formal directive as opposed to an email.
I've received emails from different agencies, if that's what you're getting at.
So you have no understanding or memory of a distinction that's captioned as a formal directive. Is that fair to say?
Correct.
Okay. And so the other question I had for you is, did you in any way participate in preparing the responses to Exhibit 20?
No, ma'am, that's not my section.
Okay. And do you know whether or not Becky Hoffman in any way participated in drafting the responses in Exhibit 20?
Not that I am aware of, ma'am.
Okay. I have nothing further at this time.
Thank you, Commissioner O'Brien. We can take that down. Zach, thank you. So do we have, Commissioner Skinner, I see, do you have questions for Mr. Curtis?
I just have a couple. Mr. Curtis, just help me lay the foundation for further questioning of your colleagues. When did DraftKings receive its temporary license in Massachusetts?
I believe the temporary license was issued on February 28th of 2023.
Okay. And when was DraftKings licensed in Tennessee?
Excuse me. I don't know that off the top of my head, ma'am. I'd have to look that up.
Okay. That's all my questions, Mr. Curtis.
Thank you,
you,
ma'am.
Commissioner Skinner. Commissioner Hill?
All set at this time, Mr. Chairman.
I'm all set also.
So just a point to maybe take judicial notice of. My understanding is we voted to authorize the application on January, I think, 6th of 2023. I could be wrong on that, but when I went back through, my memory was that was when, or I'm sorry, January 11th was the vote to award it to DraftKings.
But I don't think the license was issued. I think we approved
The application.
application and the action, I guess, of the future action of DraftKings submitting a request for a temporary. I'm not sure when we issued that. And so, I mean, we have that information, so I could find it. I'm sure it's in some of the exhibits.
From one secretary of the MGC to the other, I promise they're there. And there's all kinds of secretaries on here. All right, so we have nothing more for Mr. Curtis. Does anyone have any questions for anyone else who's been sworn in as a witness today?
I do.
Commissioner O'Brien?
Certainly, and some of this, and I say this to Attorney Harrington, because there may be parts of these questions that you may ask to go in to private session. So I will ask them, and maybe if Mr. List delays a response, to give you time to, if you feel like I'm going in an area that you would rather ask that we go into private session.
Yeah, appreciate it.
Okay. So I guess good afternoon, Mr. List.
Good afternoon, Commissioner O'Brien.
Just some follow-up questions. I watched the interview that you gave to the IB that was somewhat referenced by Attorney Banks. And you had described at one point there are state owners, meaning there are certain sort of people that are designated to be responsible for particular jurisdictions. Is that accurate?
Yes, that is accurate.
And you identified a Kevin Nelson as the individual who's responsible for Massachusetts?
Insofar as my team communicates with the commission, yes.
And was he employed and in that role at DraftKings in the fall of 22 and early 23?
Presuming you're referring to the time of around the launch
The
of
application and the GLI review and the opt certificate. Yes.
Yes.
And what would have been his responsibilities in that time?
I mean, similarly to, I guess, the way that I expressed it in the interview, he himself and my team are ultimately responsible for the communication back and forth with with the commission. But there is sort of I guess, a transfer of contact volume over time between licensing, who's usually involved first in setting up the application process, and then as we establish contact points with the staff, the relationship naturally moves to our team, and in sort of the way that it works today.
And then at some point you talk about your team having responsibility by default. At what point does it shift from licensing helping with the application to a different team making sure there's compliance for launch?
So we do. So our team reviews regulatory guidance, if that's your question. Yes.
And at what point would that shift from Mr. Curtis's group over to your group?
Mr. Curtis's group is not reviewing regulatory guidance. When I talk about the shift, I mean more in the sort of time linear flow of.
Right. That's what I'm talking about too. So do you recall at what point in the end of 22 and into 23, your group would have become responsible for regulatory compliance in Massachusetts?
No, I mean, I don't recall, I guess, the dates where we would have first started reviewing regulations, but as soon as we become aware that there are proposed regulations, even if they're not in sort of the final form that they'll be when we launch them, then we start reviewing them.
Okay. And you are aware that the legislature passed 23N in Massachusetts in August of 22?
I don't recall the exact dates of
Okay.
the legislation was passed.
So just, I think we can take judicial notice that it was signed by Governor Baker on August 10th of 2022. And are you also aware that Section 13D specifically says you cannot take any form of credit card payment on wagers?
I'm aware of the language that you're referring to. Yes.
Okay. And that was in effect on August 10th of 2022, correct?
Again, I don't personally recall the dates, but I have no reason to think that what you're saying would be inaccurate.
Do you recall the first time you read 23N?
No.
Have you read 23N?
I assume that, again, I'm not like, I don't have a perfect citation memory of, I guess, what you're referring to, but I assume you're referring to the credit card language. And if that's the case, then yes, I'm familiar with the language.
So I was asking in general, have you read the overall statute?
Yes.
Okay. And then were you aware that December 22nd, 2022, the relevant CMRs at issue in this incident were enacted by emergency by this commission?
Again, I'm not aware of the exact dates, but I am familiar with the language you're referring to.
Mm-hmm. So there was quite a bit of conversation in terms of the spreadsheet that you would get the relevant regs, and then they would be put into a spreadsheet, and then you would check to make sure that there was compliance. Is that accurate?
Yes.
Okay, so more than a month prior to January 26, 2023, when that email came over to Bill Curtis's group, there was a reg, as well as a statutory site, that banned the use of credit cards on sports wagering in the Commonwealth. So my question is, was that reg reference, a statutory reference, in the spreadsheet that you used? And if it was not, why not?
I believe that it was, and also reviewed.
Okay, so my follow-up question to that, and Mr. Harrington, let me know if this is terrain where you're asking for anything. Can you tell me why that was not complied with?
Yeah, I mean, if to the extent that how we action regulatory guidance, we would request that this be in exec session.
Okay, so we can table that one for the private session. Did you have, Mr. List, did you have anything to do with a communication at all with GLI in completing their March 7th, 2023 report in connection with the operations certificate?
I think the report that you're referring to is the product of a separate piece of documentation that was requested by the commission that GLI was reviewing. Is that your same?
Right, where they go through all the regulatory requirements, the technical requirements, and they check off whether or not it was in compliance.
So I wasn't directly working on that, but my team worked on this. Yes.
Okay. Do you know who on your team worked on that?
This would be a sort of part of the responsibility that's within my team's remit for state launch. So that is a Kevin Nelson part.
Kevin Nelson. Okay. And then there is a reference to 23 and section 13, as well as one of the relevant CMRs in that GLI section of compliance. Do you know, there's a representation in there that there was no non-compliance issues located. Would Kevin Nelson be the individual to direct those questions to in terms of how that came about?
You mean exactly how that specific sentence was filled out by whom?
By GLI, correct.
Yeah, yes, I don't know the answer immediately, but I'm not sure it requires Kevin specifically to gather it. I'm sure we could gather the answer for you.
Okay, I would ask for that.
Yeah.
And then at a certain point, you made reference to having a conversation with MGC staff about language they wanted you to put into the House rules. Do you remember that part of your interview?
Yes. So I actually wasn't me that had the conversation directly, but I do remember what you're discussing, and I'm happy to speak to try to speak to any questions you might have.
Who was involved in those conversations directly?
I'm actually not 100% sure, but most likely it was Kevin, and I'm happy to confirm that with you as well.
So you commented that it, quote unquote, raised alarm bells in terms of this particular issue. Can you elaborate on that? And again, if there's an area that Mr. Harrington wants us to reserve for private, I'm happy to do that.
I think this is going to be, the answers to both questions are going to be similar. So I think it's probably, if you decide that they're not similar, when discussing the private session, I'm happy to have Mr. List repeat, but I'm anticipating, I think the answer to both of those questions are the same.
Okay. So I'll withdraw that for private session. And my last question, Mr. List, you make a comment toward the end of your interview that end-to-end testing should be done for these types of things, meaning the fixes on the credit card ban. Can you elaborate on that? And again, Mr. Harrington, if you'd like him to do so in private session, you let me know.
It's considering we're going to go anyway for other answers to the, I'm not exactly, I think that's probably the response would be something, but in the event that it's not, we can repeat it in public session.
Okay. That's all I have for now, Mr. Chair.
Thank you, Commissioner O'Brien. Commissioner Skinner, I see your mic is off.
Yes, thank you. My questions I have for Mr. List. And at the outset, I will say I am not as practiced as Commissioner O'Brien is questioning not having served as a former prosecutor. So bear with me. What's your understanding, Mr. List, of when DraftKings received its temporary license in Massachusetts?
Sorry, I'm not sure I understand our understanding of when. You're asking me the date at which?
Yes.
I don't recall the specific date.
Okay. When did you become aware of the January 26, 2023 email from former Executive Director Karen Wells?
I don't recall the exact date of that either.
Then I'd ask that you obtain that information for us at a later time. Do you know when DraftKings was licensed in Tennessee?
Not the exact date either, but certainly sometime before Massachusetts, something like a couple of years.
Okay. By a couple of years before? I'm sorry, is that what you said?
Yeah, so something along those lines.
A couple of years before you were licensed in Tennessee, a couple of years before you were licensed in Massachusetts.
In the state of Massachusetts. Again, I don't remember the exact dates off the
Okay.
top of my head, but they're easy to follow up.
Yeah, I'm just confirming I heard you correctly. And you don't know what prompted the email from Karen Wells, do you?
No.
So to your understanding, the discussion relative to house rules that you referenced and that Commissioner O'Brien asked you about had nothing to do with the email from Karen Wells? Are they related? Were the discussions related, I guess, is my question.
Yeah, I think I'm not sure if your question might sort of cross over with, I'm happy to answer your question. I'm not sure if it crosses over with Commissioner O'Brien's question, and it may make more sense to handle the whole thing in executive session.
Yeah. Jake, let's assume it does. And so I'm happy to reserve that question for a private session. And if we need to have it answered in public, we can do that. What was the substance of the House rules discussion you referenced in your interview earlier in this proceeding?
Yeah, so there is a piece of language in the House. Well, it's common in the House rules to refer to regulatory prohibitions. And there is a section in the House rules that labels the credit card prohibition. And we were contacted by the MGC about the specific wording that we had with a request to modify it. And that sort of kicked off what Commissioner O'Brien had referred to as alarm bells, that may have been my words.
When did the discussion occur?
I'm not sure exactly, but it would have been, very much around the time, the day of that we had this communication from the MGC that requested a change in the language that we already had in the House rules.
And who did that communication come from at MGC?
I don't recall off the top of my head, but again, these are easy details to dig up.
Okay, please do. Was it written communication or oral communication?
I actually believe, again, I'm not 100% sure these facts are off the top of my head. They're a long time ago, but I certainly believe there was written communication on this topic.
And I'm guessing you're going to tell me that you don't remember the date of this communication.
No, but again, it's easy for us to get those emails for you.
Okay, so this is communication, written communication from someone from MGC in connection with House rules language that you received, not you personally, but I'm assuming not you personally, I'll ask you that later, but that DraftKings received. This was prior to the January 26, 2024, January 26, 23 email from Karen Wells to Rebecca.
No, I believe post. I mean, just to sort of try to get to the point. I think what you're asking me to do is sort of timeline out, how we.
I'm very clear about my questions to you. I'm asking what I'm asking.
Okay, sure.
Did this communication with a member of MGC occur before January 26, 23?
I'm not certain off the top of my head.
Okay. You'll find that out for us.
Absolutely.
Thank you. I think, actually, I know in your interview, Mr. List, you indicated that the email from Karen Wells was misinterpreted. Do you recall that?
Yes.
Could you elaborate on what you meant?
I can't paint it more clearly than what's provided in the internal communication exhibit. So that is exactly what the internal communication was about that email.
Which exhibit are you referring to? Sorry.
Yeah. Let me just check. Sorry.
Is it the Slack one?
Yeah, it's that one. So it's exhibit 7.
Okay, my question is to you personally. Did you misinterpret? First off, we're not. I'm waiting for a follow-up response from you to my question as to when you personally became aware of that email. But relative to the question at hand, once you saw that email, did you misinterpret it?
No, I fully understood it, and I didn't sort of mean to re-ask your own questions for you. While I can't give you the dates, I can tell you the order of the order of me coming into this information, which was first this issue was brought to my awareness through this conversation about the house rules, and then the email was brought to my attention, and I did not have any lack of understanding about what the intent of that email was when I read it.
Okay. When you became aware of the discussion relative to the house rules, what steps did you take to ensure that DraftKings was in compliance with the statutory and regulatory language relative to use of credit cards?
Well, it was that moment that immediately kicked off internal review that the way that we had implemented the credit card block, which was just based on geolocation, may be different from what the commission had expected of us. And that, in very short order, led to us reporting it as an incident proactively, and also putting in place what we believed at the time had fixed the issue.
What was your understanding of what the commission expected of you at that point?
So I think this is going to involve the same line of questioning that Commissioner O'Brien had, and I think it's all going to be one answer. So I think we can just reserve, if that's all right with you, Commissioner Skinner.
That's fine. Question to Attorney Stembeck, excuse me. Is there someone recording these questions that we're taking to the private session?
You're looking at them, so
perfect.
I'm keeping track.
Perfect.
So I'll do my best. I'm flagging everything that is coming up for private session, Commissioner Skinner. So when we make the shift over, I can refresh memories as necessary.
Okay, thank you. Mr. List, back to you. At the time DraftKings launched here in Massachusetts, what was your understanding of the requirements relative to credit card use?
My understanding was that deposits by credit card were prohibited in Massachusetts, and that was implemented, as my understanding, based on geolocation.
So you did not understand at the time DraftKings launched that credit cards deposited outside of Massachusetts were prohibited from being used here in Massachusetts?
That's correct.
You did not understand that to be the case?
That's correct. I did not understand that to be the case.
Thank you. When did you come to understand that to be the case?
I think this loops back to the same question regarding the House rules.
Okay. I'm fine. I'm fine. Again, taking this to private session with the understanding that anything that can be answered in the public session be done. Bear with me, please. The email from Karen Wells came on January 26, 2023. DraftKings launched on March 10th, 2023. It reported the non-compliance issue for the first time I believe on or around June 21st, 2023, or at least that's the date of the incident report. I understand that there might have been a phone call prior to, well before that June 21st, 2023 date. And so what were conversations, internal conversations with DraftKings individuals between March 10th, 2023, when you launched, and the date on which you identified the non-compliance issue?
Sorry, what type of conversations do you mean?
Relative to the non-compliance, relative to your identifying that the Massachusetts requirements had been misinterpreted.
Well, I think as I tried to answer, in very short order, once aware that we were not meeting the expectations of the MGC, the first step's notification. So the first step isn't the filing of the incident report.
Can I pause? Can I have you
Yeah.
pause there? When did you become aware that you were not in compliance?
As a result of this conversation about the House rules, we're sort of going back to back to the same question.
Okay, but I think earlier you said that conversation happened before the January 26, 23 email from Karen Wells.
No, I said I wasn't sure.
Okay, you weren't sure. Okay, so but you're going to check that for us, right?
Sure, but I can say with real confidence that the conversation about the House rules is what brought the issue to my attention, and also what kicked off everything else that happened after that internally for understanding that there was an issue, reporting it, remediating, and so on.
So is it safe to say, and I know you're going to confirm this date for us later, that House rules discussion occurred sometime between January 26, 23 and the date of the occurrences that precipitated the June 21st, 2023 incident report?
Sorry, that the conversation about the House rules predated the incident report. Yes.
It occurred between those two dates. Had the conversation, and sorry, I so much of my questioning rests on the information that we're not able to get today.
Sure.
But the conversation, to the best of your recollection or knowledge right now, did not occur before launch. That House rules discussion did not occur before March 10th.
These are important sort of, it's important that I give you accurate details. So I think I tried to explain, I guess, the order of, when we understood there was a problem and what happened next. But I don't without being certain of the dates, it's not prudent for me to make an educated guess for you.
That's fair. That's fair. That's very fair. So I'll stop my line of questioning relative to that with the understanding that I believe we're going to be holding this proceeding open. And so I do reserve, and I reserve the right, and I very much expect to come back to this questioning when we reconvene on this matter. Commissioner O'Brien, if you have another question, or Commissioner Hill, or anybody else, you can go. But so while I just check my notes to see if I have anything else for Mr. List.
So Commissioner Skinner, I'd like to give Commissioner Hill an opportunity. I am serving as interim chair to ask any questions, and then we'll go to Commissioner O'Brien.
Actually, Mr. Chairman, I do have a couple of questions. However, I noticed that we are at the 4 o'clock hour, and it was my understanding that we had to have a hard stop due to some family obligations from staff. And I was wondering if at this point it might be appropriate for us to go into a recess and come back at another time.
So Commissioner Hill, I'll put my belief on that, let me see. I think we should probably enter in a private session on the questions that Commissioner O'Brien asked. I'm looking at Commissioner O'Brien to see what she thinks. There were
I have a
three.
couple other that can be asked in public, and then we could go, unless
then
there's
we
a hard
could
stop,
go.
and then we can suspend.
And then what we could do is actually leave from there. Leave from there and not move on to any other witnesses today. Does that sound okay?
That sounds okay. And when we come back from our recess, I do have some questions for Mr. List.
So I'm sorry, I just want to understand process here. So I do have some additional questions as well for Mr. List that I can hold to another session if we are going to be holding this proceeding in recess. Because I believe so that's what you were referring to. So I believe that the private session may inform my questions, my remaining questions, so we can, and the detail about the dates that we expect from Mr. List will also inform the remainder of my questions. So I'm going to yield on questioning Mr. List any further for now.
Okay. Mr. List, if you may, let me get to Commissioner O'Brien. Commissioner O'Brien, did you have anything further?
I have additional. There's one I would like to ask today so that I don't forget, and then I'll reserve. Mr. List, directing your attention to Exhibit 20, which is DraftKings response to the IEB supplemental questions dated March 29th of 2024. I put it up earlier when I was asking Mr. Curtis some questions, and there is a number of references to that sort of nuance and alleged miscommunication of Karen Wells's email. Are you familiar with that document?
Yes, but I'm going through our internal numbered lists, and for whatever reason, I don't have something as labeled Exhibit 20. So if you're happy to, wait, just give me 10 seconds to find it. And if not, I might ask the screen share again. Oh, I think I have it. For some reason, we have it labeled as 19, but I have it.
And did you participate in drafting the answers on Exhibit 20?
Yes, I did.
And who else participated in drafting the answers to Exhibit 20?
I'm just looking through this. I mean, as with other written responses we've provided to the Commission about the production of these reports, it's quite a collaborative effort. So we go back
I'm just asking if you can give me the names and titles of the other individuals who participated in drafting these answers.
Yeah, but I mean, in the same vein as what I'm describing to you, I'm not sure everyone that worked on this report, but I'm certainly one of the main people involved in drafting the actual responses. And then they go under legal review.
So I would ask that I would like a list of who participated in drafting the answers going forward when we meet again. And specifically, I'm going to direct this question to you, Mr. List.
Yep.
There are a number of allegations in 1.1 on the first page of Exhibit 20 that imply that Ms. Wells's email of 12623 had nuance or created a misunderstanding. Did you participate in drafting that response?
I participated in drafting the response. I certainly don't think, so you used the word allegation. We said this in the response. I believe it's in the, hang on. Not sure exactly the moment in the response, but I think we were very clear to identify that we were not trying to make any allegations of the MGC, and particularly not anything about fault in the interpretation of the guidance. We were merely trying to establish what the sequence of events was, because you'd asked us why in writing we referred to it as anomalous. So it was merely to describe that it was anomalous, not that it should have been handled differently by the MGC. I want to make that clear.
So the nuance and the lack of clarity is entirely on DraftKings' part. Is that a fair statement?
I don't think I'm not trying to, I guess.
I'm going to stop you, Mr. List, because I would like to withdraw that question, and I'm going to read from General Laws 23N 13D, and the statutory language enacted on August 10th, 2022 says an operator shall not accept 1, a wager from a person who is less than 21 years of age, or 2, a credit card. There is no geographic limitation to that statutory restriction. It was then enacted in December of 2022 by emergency on 2 different regs. And if there is any way, Zach, that you could put up Exhibit 6, Karen's email, please, because I do want to get this on the record. And can you see that, Mr. List?
Yeah, as previously explained, I've read, and
I'll put a question in front of you. There's no question in front of you right now. The question I'm going to put in front of you is, it starts saying, Becky, I am reaching out to all Cat 3 operators to confirm compliance with Massachusetts law requiring the prohibition of credit cards for sports wagering. Could you please get back to me with the following? Did I read that accurately?
I think you have read it accurately, yes.
Okay. And were you confused at all by the statement that Massachusetts law prohibits credit cards in that email?
No, as I also said to Commissioner Skinner.
Okay, you've answered my question. You did not have confusion on that point, correct?
That's correct.
Okay, I have nothing further at this time.
Zach, if you can take that down so I can see everyone. Thank you. All right. I think we exhausted everything except I hadn't said anything yet. Commissioner O'Brien's line of questioning in her first round on knowledge covered everything I had planned on asking, so I'm not going to repeat the questions. With that said, commissioners, do we agree there were approximately 3 questions that Commissioner O'Brien had that Justin wrote down. I think there were 2 questions that Commissioner Skinner attached very similar to Commissioner O'Brien's. Are we okay with moving into private session? And Commissioner Skinner, you can correct me if I was wrong on that.
No, I'm okay with moving into private session. However, I'd like if we don't have someone who captured the questions as they were being asked, I would like the opportunity to go back and review those questions so that I can make sure as we are in the private session that they're asked again and fully answered.
Commissioner Skinner, I'm pretty sure I have them.
Good enough.
So when we go to private session, we can walk through each one, and hopefully we cover it all.
That's what I was going to ask, if that was okay. So that's okay, Commissioner Skinner?
Yes.
Commissioner Hill, Commissioner
All
O'Brien.
set. Yep.
All right, so we will enter into private session. Let me go ahead and get this off too. Do we plan on going back into public session or leaving from private session and holding all of our questions for Jake until the next time we reconvene on this matter? What do we want to do?
Just procedurally, Mr. Chair, what I would
Yeah.
suggest is that I know there's questions being held for what informs the commissioner's thoughts after the private session. I would suggest that we would, in public session, it could be after we go through these limiting serious questions in private, we would come back and just note any other material that the commissioners want to see. I think that should go on the record so that everyone understands what additional information we're seeking before we come back and reconvene at some future date. If that makes sense.
Commissioners, are we okay with that suggestion? I am.
I am, and in addition to that, sorry, Mr. Chairman, if you said this already, any responses that we receive in the private session that were not appropriate for private session, I'd
We
ask
can
that
repeat.
come back to repeat, today, rather than holding those until the next session. Thank you.
Yep. All right, so let's move into private session. Give everyone a second, but then Connor, you are free to take that down, or Mills, whoever's taking it down, whoever's driving. Thank you, Connor. So we just finished private session with Mr. List, and we're entering back into the public session. I do want to take this opportunity to ask the commissioners if there are any further questions that we will have, understanding that we believe, given some of Mr. List's answers, that we will have to get more information from the licensee, and we'll probably have follow-up questions based upon the information we've received. So with that, I will open it up to commissioners. Any other, let me go ahead and I can read the formal language. Is there any, want to make sure I get this right. Any further matters that you would like to address, period?
I think I'm reserving my answer to that question until we resume. I think there's been direction given to our legal and to the operator in terms of what we're looking for, so.
Thank you, Commissioner O'Brien. Commissioner Skinner.
Same. Thank you.
Commissioner Hill, I see your mic's off.
Yep, thanks.
And I feel the same. So with that, Councilor Stimpik, I see your mic's off.
I would just note for the benefit of the commission that I've taken notice of all the requests for additional information, be it documentary. I know that there have been requests that certain other witnesses be made available for questioning by the commission. If there's any particular individual that you think may not have been referenced that you do want to hear from, I would just, for my benefit, frankly, if you could go back through that list of those individuals, it would be helpful just so I can have it in one list. I've kept track of all the documentary requests, but if we have witness requests and we can just go through those quickly now, that would be appreciated. Thank you.
Thank you. I know that Kevin Nelson was one of the names, correct, Commissioner O'Brien, that you mentioned?
There were a series of individuals, to be honest with you, involved in some of the conversations at issue. And I don't know whether I'm going to want to hear from all of them, but if we're making an over comprehensive list, Rebecca Hoffman is one of them. Joseph McCann is one of them. Dixon J, Grace Tate, and I've already mentioned Kevin Nelson. And the answers that we asked for may expand or contract that list as well.
Okay. So was that helpful, Justin?
Yeah, thank you. I wrote down the list. But,
yes, Commissioner Skinner.
On the MGC side, I think it would be helpful to have someone from our sports wagering division who could speak to some of the discussions referenced in the proceeding, the House rules discussion, for instance, to the extent that there is anyone. The email relative that came from Karen Wells on January 26, 2023, to the extent that there is anyone in house currently.
Okay, Commissioner Hill, do you have any? I would just reiterate that anyone who, in addition to what was requested by the other commissioners, anyone that made themselves available today, we would want them also made available for further questioning. We are keeping, and that may be redundant to even say, given that we are keeping the record open, we are going to reconvene at a point to be determined by the parties here today, along with the commission. Any other magic words, Councilor Stimpik, I need to use?
No, Mr. Chair, I think you can simply indicate that the commission will take a recess and we will reconvene on a future date to hopefully complete the remainder of the hearing.
All right, thank you. So we will take a recess, we'll reconvene, and I appreciate the candor and all the work that went into this from both the IEB as well as our licensee. And we look forward to meeting again and working to resolve this matter. So thank you so much. Have a good Thursday.
Thanks, everyone.